Good morning, sir. You're Clayton Friddle.
Yes, ma'am.
And Mr. Friddle's cases in cause number 25 DCCR 0450, 0451, and 0452, all charged with official oppression. And Mr. Gertz, what is the announcement?
Judge, still working through these. I think we can have a real answer in 30 days. We can have 30 minutes.
Mr. Smith, any issues? This will be the last, looks like you filed your letter of rep at the end of April. So this will be the final reset. Make sure you get in to visit with Mr. Gertz before that next court date so that we know what we're going to take care of, how to take care of your cases. Okay? All right. Thank you. You're free to go. All right, did you get that last? Good morning, sir. You're Dustin Knight. And so is this a re-indictment or is it two cases?
It's a re-indictment, Judge.
All right. Can we
Just change the language. We've discussed it. It's
We're
the
agreed.
same charge. it's
Sure.
just a
You can
cleaner
just,
change in the
if
language.
you don't mind getting that other one dismissed, now that it's been indicted, that'll clean up
Okay.
what I'm looking at as well. And sir, you're Dustin Knight,
Yes, ma'am.
and Mr. Knight is charged with collision involving death. Case set for trial to begin with jury selection next Monday. Mr. Gertz and Ms. Molfino contacted me Friday. I know Mr. Gertz has two different things going on that seem to take precedence over this case, which is unfortunate because of the age of the case. Obviously, everybody knows that I'm ready to get it tried. I know that the complaining witnesses and victims' family are obviously ready to get this tried as well.
And
It
I
has their,
spoken with them
have you?
about those issues, Judge, yes.
Okay.
You know, they're very understanding. We talked through them when Mr. Gertz and I spoke as well. I have also filed, and I'm sorry to interrupt.
No,
just
I'm glad
put all
you,
this
no,
on the
please
record.
do.
I've also filed numerous documents in this case that was brought to my attention this morning. They did not go through the e-file. They've been e-filed, but they didn't process, I guess, because of the holidays. So I anticipate, I've shared what I filed with Mr.
Okay.
Gertz as well, and I anticipate there'll be more things for the court to address in signing those, but I don't foresee any reason we couldn't be ready for trial very shortly.
So, Mr. Gertz, has there been any change that you know of with regard to either of those? I know you've got a
Judge,
case next door with Judge Stevens, and then also Judge Thomas has a
My answer is.
protective
I would
order,
do-
right?
He does, Judge.
protection. Okay.
I would love to tell you yes, but I can't.
Okay. So just so that because of the nature of this offense and the witnesses and everything, I'm going to go ahead and reset it today. And then we will get it set on the next available trial docket. Make sure you stay in touch with Mr. Gertz. If anything changes between now and then, y'all let me know. Obviously, I'll take a look at whatever comes through. And if there's something we need to do before the next court date, legally or whatever, then we'll take care of that as well.
I don't anticipate that, Judge, but
Okay.
with the court's permission, before Ms. Holmes sets it on a docket, would you mind if I reach out to the family just to check their schedule, just kind of, I need to try to work around the kids, the young kids' spring break, and also the wife of the decedent
Sure.
is taking a full load at Lamar right now, and so she just asked me kind of to be cautious of the dates so that she can work around some stuff.
Yeah. So if you'll just make sure, we'll talk about it and get with Ashley on that. Okay. We'll take care of that.
Okay, thank you.
Thank you. All right, you're free to go. Good morning, sir. You're Miguel Martinez. And this is 25 DCCR 0584. Mr. Martinez is charged with aggravated sexual assault of a child. Mr. Gertz, what is the announcement?
Judge, we're still working through the discovery of this case. I don't know exactly when it was indicted, but this may be our first or second appearance, so.
Looks like you filed your letter of rep June 3rd. So,
It's longer than I thought.
yep. Any issue with the reset?
Nothing that we're aware of, Your Honor, so no problem with the reset.
So we're getting close to that time on this one. So I'll do a reset. Mr. Martinez, make sure you stay in touch with Mr. Gertz so you guys can go over the case and we'll see if we get an announcement at the next court date, okay? You're free to go. We're
You want
here.
some background or?
Yeah, so, well, it looks like we're here on a motion for early termination.
Yes, Judge.
Let me look at this. So Mr. Rogers is on probation for two cases. In cause number 20-34772, on probation for aggravated assault with a deadly weapon. Was placed on was a 10-year deferred, is that correct?
That's correct. Judge.
October 26th of 2020.
Yes, ma'am.
And then, oh, thank you. And then in cause number 20-34493 on probation for aggravated assault causing serious bodily injury, same thing, deferred probation for 10 years on probation, from the same date of October 26th of 2020, is the date of that probation, correct?
Correct, Judge.
And Mr. Gertz has filed motions in each of those cases for early termination.
Judge, I know typically this is something that you reach out to us in advance and just get our input on it. I just wanted it to be on the record due to the nature of the offense. I've spoken with his probation officer, and I don't believe she has any issue with an early termination. He
I don't-
also successfully completed Veterans Court and has done very well. I just was hesitant due to the nature of his offense.
So my issue with this, and I did get Ms. Malfino's response when I sent it to her, the judicial clemency part is my issue, based on the nature of the offenses.
It's deferred or is it straight?
It's deferred.
It's deferred, so judicial clemency wouldn't be, I write judicial.
You
clemency.
did.
Oh, well, you don't need to grant judicial clemency because he doesn't have a conviction.
Right, that's what
And
I,
I think that was an issue I wanted.
yeah, I
you-
definitely
you-
did not.
I'm
I
sorry, so
definitely
that
do-
was just a holdover, I think, that I just didn't notice in our filing, so I apologize. So sometimes that comes up, but only with a conviction case, Judge, and these are
Right.
both deferreds. So judicial clemency shouldn't be an issue.
I did also, for the record, get a response from probation from Ms. Martinez that states that pretty much what Ms. Malfino stated, that he successfully completed the veterans program, completed anger management, that he has done well. They just, due to the nature of the offenses, aren't going to make that recommendation and would defer to the court, but are not opposed to it. And that's the position of the state as well. Then at this time, I will grant the motion for early termination of community supervision in each of those cases. I am going to mark through some of this, well, I'm gonna mark through that, request, that the request came to be considered, and motion for, through that. So I just marked through the part that talked about judicial clemency.
Okay, thank
And
you,
I
Judge.
have granted-
I apologize for that.
Nope, that's okay.
That's an oversight on my.
So, Mr. Rogers, it sounds like you've done great. You're what we want to see with everybody on probation. You've been on for a little over half of your probation period, so you're entitled to early termination if you've done certain things. This is the type of case where I'm glad to be able to say that you've done it all. And you, I'm signing the order today, so you will be off probation. All right, good luck to you. Thank you. This is Ms. Malfino. Oh, she's right there. She's coming. It's all good. Good morning. You're Ryan Hodge. And Mr. Kimler, will your client waive the formal reading of the indictment?
So waived.
And we're going on the full indictment, correct?
Correct, Your Honor.
Mr. Hodge, in cause number 24, DCCR 1167, you're charged with third-degree felony offense of evading arrest or detention with the use of a vehicle from April 11th of 2024. Your indictment further alleges that you were previously convicted of burglary, a second-degree felony, May 12th of 2015 in Grady County, Oklahoma, and on that same date, also convicted of possession of a controlled substance in Grady County, Oklahoma. And then after those were final, you were convicted March 20th of 2018, also in Grady County, Oklahoma, of bribing an officer, and on that same date convicted of a felon in possession of a firearm in Grady County. How do you plead to that charge? So how do you plead to the original charge that you're evading arrest or detention with the use of a vehicle? And are those prior convictions true? Did you enter your plea of guilty in true, freely, and voluntarily? And because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And so, is there a fine agreed to?
I marked a fine, I would look that up to the state.
500 is fine.
So it looks like the agreement that you've reached with the district attorney is for a 10-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? I want to make sure you understand that because you've entered a plea of true to all of those prior felony convictions, that this is a little different than a normal 10-year deferred. If you violate, your minimum punishment by law that I could give you if you violate this probation is 25 years, non-negotiable, because you've pled to it this way. If you violate, the minimum is 25. Do you understand?
Yes, ma'am.
Okay. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
Without objection.
It's admitted. Is there any evidence that Mr. Hodge is not competent?
None that I'm aware of, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That will give me more information about you, your case, and then we'll come back later for sentencing. Do you have your discovery certification?
Yeah,
Okay. Go
May
ahead.
I inquire if he has a GPS, Judge? I know he resides in Oklahoma. I don't know if that would be something that,
Was it part of your bond that you have a GPS monitoring device?
Yes, they have.
So are you wearing that
Yeah,
now?
yeah, they have.
Okay.
you have it on you right now.
No, they've taken it off, like, since prior. I had a problem with it, but I came down there, and I've been checking in twice a week. They've changed the stipulation of it, but
So
they
what-
said as long as they changed.
It might have been, so your bondsman had that condition on you?
Yes.
Not the court? Okay.
Yes, but she said you've been following up and going to court, everything's been good.
Okay. All right, so it's very important. Obviously today, stop and talk to probation. She's gonna let you know what you need to do. You're gonna need to go to the probation department before you leave. You're gonna have to set up that appointment for that pre-sentence report. If for some reason you don't do that and you don't follow through, then you run the risk of me not accepting the plea agreement. Obviously, things could be much worse. If you're arrested for anything between now and when you come back for sentencing, obviously, I'm not gonna accept the plea agreement. Things can be a whole lot worse. Do you understand? All right, stop and talk to probation. We'll see you at sentencing. Ms. Nguyen, in cause number 24 DCCR 1298, you're charged with the state jail felony offense of theft of property from April 8th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And so is the agreement, it looks like, for a 12-month term in the state jail prison?
Yes, Your Honor.
Yes,
She
Judge.
has 11 months
Okay.
of back time.
Okay,
So she would have to serve one more month.
okay.
The defense is requested if she could turn herself in on Friday. She has 3 children that she needs to get situated.
Well, so what we need to do is, I'll go through with the plea, but not sentence her, because if I sentence her, it just turns into an issue if she doesn't.
Okay.
But motions for new trial and things like that, there's really not a lot of things we can do. So, I can take the plea today. We can do the sentencing Friday. We can do the sentencing Monday during the next docket.
Okay.
I'm willing to do the week, whatever.
Couple of things, Judge. If we can maybe put on the record how we arrived at that time. And also, there's the state, well, ordinarily, I wouldn't be opposed to a defendant turning himself in at a later date. This plea was contemplated prior to today. In other words, this defendant knew that there was a very good chance that she would be going the other day. On its face, it just looks like a plain Jane state jail felony theft. But Judge, it appears that she may have been a part of a theft ring that committed more than about 29 total different crimes to the tune of about $50,000, Judge. So with all that being said, I'm not so amenable to her turning herself in later, but of course it's up to the court.
So here's what we'll do. We'll go through with the plea. And then we'll be here and do sentencing this Friday at 9 a.m.
Yes, ma'am.
Can you do that?
I have municipal court in the morning, but
What time?
they typically start at 8:30. But I could,
I mean, it won't take long.
yeah, I could tell them I'll need to leave and come and go back.
I mean, we can do this at 8:30, and then you can just, instead of starting and stopping, and just be, I mean, it'll
Little
take
late,
10
yeah.
minutes.
Okay,
Would you rather that?
Yeah, that's
Instead of starting and stopping, just let them know you'll be a little bit late?
yes, that's fine.
Okay, so that's what we'll do then. All right, so, and you guys have talked to the clerk about the credit?
Yes, so there were several counties, in which Ms. Wynn was transferred throughout, from 2024 to 2025.
For various things.
Okay.
Yes, from various steps in various counties. So we have, we know that Jefferson County put the hold on her in June of 2024,
Okay,
and then she was released in May of 2025,
okay,
after completing all the other counties.
okay,
Yes, ma'am.
gotcha. All right, so is that your understanding of the agreement?
Yes, ma'am.
And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Wynn is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing to this Friday, which is January the 9th, thank you, at 8:30 a.m. It's very important that you're here on time because Ms. Holmes has something else she needs to do in another court. And so we'll all be here early. We'll get your case taken care of. You'll go into custody. If you don't show up this Friday, well, just let me go. Good, I hope so. But let me just, if you don't, then I don't have to accept this plea agreement and things could be worse. You understand? Also, if you're arrested for anything this week between now and when you come back Friday, you run the risk of me not accepting that agreement. You understand? And it sounds like there's the hold, there's some documentation of the hold that we had. And so the credit from that June date in 2024 to the release date in May will be granted as far as back time.
Yes,
Did we already admit one?
No, Judge.
State tenders number 1.
no objection.
It's admitted. Is there any evidence that Ms. Wynn is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, again, I'm going to reset your case until Friday at 8:30. We do not need a pre-sentence report. You'll come in and be ready to go that day with the bailiff, okay? All right, we'll see you Friday morning. And you've got your certification?
I gave it to you.
I have it. You have it? Okay. All right, thank you.
Yes, ma'am.
So,
In today's court proceedings, Judge Raquel West handled multiple criminal cases involving serious charges, including official oppression, collision involving death, aggravated sexual assault of a child, and repeated felony offenses across several defendants. The court reviewed prior records, probation violations, and criminal histories spanning multiple states, while also addressing plea agreements, deferred probation conditions, and sentencing recommendations. Some defendants were granted continuances to prepare for trial or complete pre-sentence reports, while others had probation terms modified or early termination, granted after demonstrating compliance with court-ordered programs. In several cases, the judge emphasized strict conditions such as no contact orders, firearm prohibitions, mandatory reporting requirements, and the consequences of violating probation, including lengthy prison sentences. The proceedings highlighted a balance between accountability and rehabilitation, as the court warned repeat offenders while also allowing structured opportunities for reform under supervision.